promotion of local industries,
15. Section 3 of the Public Procurement Act stipulates that public procurement and disposal organs and public entities shall be guided by the following values, the national values in Article 10, equality and freedom from discrimination in Article 7, affirmative action, principles of integrity, principles of public finance, values and principles of public service, principles governing the procurement profession, maximization of value for money, promotion of local industry, sustainable development, protection of the environment, promotion of citizen contractors, unquote. Pursuant to Section 4 of the Act, the Procurement Act applies to all state organs and public entities with respect to procurement planning, procurement processing, inventory and asset management, disposal of assets, contract management. It is not in dispute the appellant is a state organ and the Act applies to it. A key issue in this appeal is to identify the constitutional and legislative framework for public participation in procurement. Public participation in procurement law is provided for inter alia through the following provisions incorporated by Section 3 of the Public Procurement and Asset Disposal Act 2015. 1. Article 10.2 of the Constitution. Secondly, Article 201A of the Constitution relating to financial matters. 3. Article 232.1 relating to policy making. 4. Article 232.1F that requires transparency. 5. Article 232.1 on fair competition. And Article 2271 which requires the procurement of goods and services by procuring entities to be competitive. The constitutional and legal issue is the scope, extent, and degree of public participation and or participation of the people in the procurement of goods and services under the Procurement Act. The Supreme Court and other superior courts have had occasion to consider the provisions of Section 3 of the Public Procurement Act and Article 10 and 227 of the Constitution insofar as they relate to procurement of goods and services, and especially in the case of the Communication Division of Kenya and the Royal Media Services and 5 others. So much from the quotation from the Supreme Court. There are several judicial decisions from other superior courts on application of public participation to procurement matters in light of Article 10 and 227 of the Constitution. The Al-Ghura'i Printing and Public LLC versus the Collision of Reforms and Democracy and 2 others. Nairobi Metropolitan PSV Saccos Union versus the County of Nairobi Government and 3 others. Click South Africa Private Limited, where it was stated in relation to public participation that, quote, it cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by regulations that are being made. What is necessary is that reasonable notice is given and the views of those who attend are taken into consideration. Then the case of Meru Bar Wines and Spirits owners versus the county government of Meru, Kituja Sharia versus the Central Bank of Kenya, Kenya Transport Association versus the Municipal Council of Mombasa, in Eric Okeyo versus the county government of Kisumu, in considering the issue of public participation in tendering process, the court expressed similar views as the cases quoted before. Our analysis of the emerging jurisprudence from the Supreme Court and other superior courts, as well as the reading of the express provisions of Section 3 of the Public Procurement and Asset Disposal Act, as read with Articles 10 to B and 2 to 7 of the Constitution, lead us to find that as a general principle, subject to limited exceptions, public participation is a requirement in all procurement by a public entity. The jurisprudence also reveals that allegation of lack of public participation must be considered in the peculiar circumstances of each case. The mode, degree, scope, and extent of public participation is to be determined on a case-by-case basis. What is critical is a reasonable notice and reasonable opportunity for public participation. In determining what is a reasonable notice, a realistic time frame for public participation should be given. In addition, the purposes and level of public participation should be indicated. Reasonableness is also to be determined from the nature and importance of legislation or decisions to be made, and the intensity of the impact of the legislation or decision on the public. The length of consultation during public participation should be given, and the issues for consultation. Mechanisms to enable the widest reach to members of the public should be put in place. And if the matter is urgent, the urgency should be explained. We find and hold that subject to limited exceptions, such as provided in Section 4.2, Section 6, 91.2, and Section 155.2 in Part 12 of the Public Procurement and Asset Disposal Act, and pursuant to Section 3 of the Act, as read with Articles 10 to B and 2 to 7 of the Constitution. Public participation is a mandatory requirement in all procurement by public entities. For this reason, we find and hold that the High Court did not err when it stated the general principle at paragraph 180 of its judgment, and quote, "We therefore expressly hold that public participation must apply to all procurements, though the degree and form of such participation will depend on the peculiar circumstances of the procurement in issue," unquote. We, however, note that the High Court, in stating the general principle, did not take into account that there are exceptions to the general principle in which public participation in procurement process is not mandatory. Public participation in procurement process is achieved largely through invitation of members of the public to bid and submit tenders for procurement of goods, works, and services. The invitation is ordinarily done through competitive and open advertisement to the public. Section 91(1) of the Act echoes this by stipulating that open tendering shall be the preferred procurement method for goods, services, and works. Section 91(2) of the Act permits a procuring entity to use alternative procurement procedures if allowed by law and stipulated conditions are satisfied. A common theme when alternative procurement procedures is adopted is that the scope of public participation through competitive bidding is reduced and progressively eliminated as we approach the direct procurement method. In Revital Health EPZ Limited versus Public Procurement Oversight Authority, Muriti J. sitting in Mombasa held that procurement conducted outside the provisions of the Public Procurement and Asset Disposal Act was not necessarily unconstitutional. Constitutionality of the procurement process is to be assessed on the basis of Article 2 to 7 of the Constitution. Article 2 to 7 provided that procurement by a state aid organ or public entity was to accord to a system that was fair, equitable, transparent, competitive, and cost-effective, unquote. In this case, from which this appeal is preferred, the trial court correctly stated in paragraph 195, quote, "We, however, hasten to clarify that direct procurement does not necessarily violate the constitutional requirement of competitiveness as long as the constitutional and statutory threshold is met in the process and proper procedure is followed," unquote. In the Okia Ontara case, the petitioners contended earlier that the procurement of the Standard Railway project was in direct violation of the provisions of the 2015 Act for failure of the respondents to take it through a competitive bidding process. The respondents submitted that the Public Procurement and Asset Disposal Act 2015 did not apply in the procurement of the SGR because Section 6.1 of the Act bars the applicability of that Act in instances of negotiated loans or grants between Kenya government and other governments or other international organs or bodies in arriving at the determination that the Public Procurement and Asset Disposal Act 2015 does not apply to government procurement. The learned judges expressed, and this is reported in our judgment. In this appeal, the critical issue is whether public participation is a mandatory requirement whenever direct procurement is adopted as an alternative method to procure goods, works, and services. It is the appellant's contention that public participation is not a mandatory requirement when direct procurement is used. Conversely, it is the first respondent's case that public participation is mandatory prior to making the decision to adopt direct procurement. The trial court in its judgment made a finding that public participation is a mandatory requirement prior to adoption of direct procurement. Senior Counsel Paul Mwite for the appellant submitted that whereas Section 103 of the Procurement Act permits direct procurement, in the instance there was no allegation that there was violation of any provisions and conditions in Section 103 of the Act. It was submitted that a reading of the judgment of the High Court in its entirety reveals that the real reason for the orders made was that there was no public participation in the tender awarded to the second respondent. That in paragraph 280 of the judgment, the learned judges observed that in this particular case they were not satisfied that there was sufficient public participation to the constitutional threshold in the decision to use direct procurement for ballot papers for presidential elections. Counsel emphasized that the reading of paragraphs 215 and 216 of the judgment shows that the High Court found that public participation was insufficient because the fifth respondent in this appeal and other presidential candidates were not informed that a decision had been made to utilize direct procurement as a method to procure election materials and ballot papers for the presidential election. On this issue, the High Court itself, paragraphs 240 and 215 of the judgment, which are also enumerated in our judgment. Senior Counsel Paul Mwite submitted that the finding by the trial court in paragraph 215 amounts to consideration of individual political rights of presidential candidates, that this finding has nothing to do with public participation, that an individual right should not supersede public interest, and individual political rights do not amount to public participation. Counsel submitted that the trial court erred in holding that presidential candidates ought to have been consulted in order to meet the threshold of public participation. That such a holding is erroneous as it equates individual political rights to public participation. The seventh respondent in supporting submissions by Senior Counsel Paul Mwite stated that the appellant is an independent commission and it would be wrong to consult candidates on how and from whom to procure presidential election materials. Senior Counsel Mwite stated that the reading of Section 103 and 104 of the Public Procurement Act shows that public participation is not one of the conditions to be fulfilled before direct procurement can be done. That these sections do not envisage public participation in direct procurement. Learned Counsel Kamau Karori for the appellant submitted that direct procurement only applies where there is an urgent need and it is not permissible to inject into direct procurement issues or circumstances that would delay urgent procurement of goods, works, or services. That the learned judges, by injecting public participation requirement into this, defeated the urgency envisaged as an objective of direct procurement. The Honorable Attorney General, while supporting the appeal, submitted that the High Court erred in requiring public participation in direct procurement. That what the trial court did was to rewrite the Procurement Act in a way that Parliament never intended. We have considered the provisions of Section 103 and 104 of the Public Procurement and Asset Disposal Act 2015 and submissions by all the parties. The architecture of procurement methods stipulated in Part 9 of the Act promotes public participation and competitiveness in procurement process in a progressively decreasing manner. The scope and degree of competitiveness and public participation is progressively reduced as one approaches the direct procurement method. Section 91(1) of the Act stipulates that open tendering shall be preferred procurement method for procurement of goods, works, and services. Section 91(2) stipulates that procuring entity may use alternative procurement procedures only if that procedure is allowed and satisfy conditions under the Act for use of that method. While Section 92 of the Act identifies the method of procurement, Sections 103 and 104 provide detailed procedures on when direct procurement may be used and the procedure for direct procurement. It is categorical that a procuring entity may use direct procurement so long as the purpose is not to avoid competition. The procedure for direct procurement is stipulated in Section 104 of the Act. The constitutional and legal issue is whether the conditions stipulated in Section 103 and 104 of the Procurement Act, as read with Article 2 to 7 of the Constitution, are exhaustive in relation to direct procurement method. The other issue is whether public participation is non-existent under the provisions of Section 103 and 104 of the Act. The trial court in dealing with this issue placed emphasis on the latter part of Section 103 of the Procurement Act, which stipulates that that procurement is allowed so long as the purpose is not to avoid competition. At paragraph 195 of the judgment, the court expressed as such: we have examined the record of appeal and are unable to find evidence indicating that the intention of the appellant to opt for direct procurement was to avoid competition. The uncontroverted evidence on record, discernible from the affidavit deposed by Mr. Ezra Chiloba dated the 27th of June 2017, provides the reasons why the appellant opted for direct procurement. At paragraph 6, it is deposed that out of abundance of caution, the appellant sought legal advice on options available to it under the Procurement Act in view of the very limited time available to procure the election materials that the appellant was advised to consider proceeding by way of direct procurement. In our view, subject to satisfying the requirements for alternate procurement methods, being the conditions stipulated in Section 103, 104 of the Act, direct procurement is constitutional. The trial court made a finding that there must be public participation before a decision to use direct procurement is made. Our reading of Section 103 and 104 and Articles 2 to 7(1) does not impose a mandatory requirement for public participation prior to using or adopting or making the decision to adopt direct procurement. Section 103(2) does not provide for public participation as one of the conditions to be satisfied prior to adopting direct procurement. On this analysis, we make a finding that the trial court erred when it imposed a requirement for public participation prior to the appellant making the decision to adopt direct procurement method to procure election materials and ballot papers for presidential elections. So long as a procurement entity meets the threshold of Section 103 and 104 and it observes the provisions in Article 2 to 7(1) of the Constitution, direct procurement cannot be unconstitutional. The conditions in these sections and articles are checks and balances that assure transparency and accountability in direct procurement. Other provisions safeguarding accountability and transparency to the public in relation to direct procurement include Article 35 of the Constitution on access to information, the role of the Auditor General, the role of the Ombudsman, and the supervisory powers of the High Court. The progressive reduction of the scope and degree of competitiveness in alternative methods of procurement, amongst other reasons, lead us to find that public participation is not a mandatory requirement prior to a procuring entity making the decision to opt for direct procurement. An issue that was urged in this appeal at ground 9 in the memorandum of appeal was that the High Court erred in compelling the appellant to come up with a framework for public participation when it stated in paragraph 200 of the judgment that, quote, the IEBC was obliged to craft and implement a meaningful program of public participation and stakeholder engagement in the process of tendering for the printing of election materials and ballot papers, unquote. It was contended by the appellant that this order amounted to the court erroneously directing it to usurp legislative powers. It was also argued that the absence of a legal framework for public participation cannot justify the High Court to usurp parliamentary power and legislate the content, scope, and threshold for public participation. We have considered this submission in light of the provisions of Article 10(2) of the Constitution and other relevant articles where public participation is constitutionally required. In our considered view, the absence of a legal framework for public participation is not an excuse for a procuring entity or a state organ to fail to undertake public participation if required by the Constitution or law. A state organ or procuring entity is expected to give effect to constitutional principles relating to public participation in a manner that satisfies the values and principles of the Constitution. We take judicial notice that the Senate is aware of the need for a legal framework for public participation, and to fulfill this need, the Public Participation Bill 2016, Kenya Gazette Supplement number 175, Senate Bill number 15, has been published. The preamble to the bill states that, quote, it is an act of Parliament to provide a general framework for effective public participation to give effect to the constitutional provisions, unquote.
I'll myself address the issue of appropriate relief. An issue for consideration in this appeal relates to the appropriateness of the relief and orders granted by the trial court. The trial court granted orders of mandamus and certiorari. The court at paragraph 219 of its judgment considered what type of relief to grant in the matter before it. The court correctly observed that in deciding whether or not to grant the relief sought, a court ought to take into account public interest. At paragraph 221 of the judgment, the court stated it was of the firm view that in appropriate circumstances, courts of law and independent tribunals are entitled, pursuant to Article 1 of the Constitution, to take into account public or national interest in determining disputes before them when there is a conflict between public interest and private interest, by balancing the two and deciding where the scales of justice tilt. On our part, we now consider the appropriateness of the relief granted by the trial court. The Fair Administrative Action Act expands the scope of judicial review reliefs beyond the traditional three, that is, the mandamus, prohibition, and certiorari. In this regard, Section 2 empowers the court to grant an order, any order, that is just and equitable, including the 10 reliefs expressly listed in that section. The term just and equitable must of necessity be interpreted to mean appropriate relief, which is the term used in Article 23(3) of the Constitution. The same has been interpreted by the court in the case of Nancy Makoha Barasa by the Judicial Service Commission as being wide and unrestrictive and also inclusive rather than exclusive, and to allow the court to make appropriate orders and grant remedies as the situation demands and as the need arises. Some of the reliefs outlined in Section 11 of the Fair Administrative Action Act include a declaration, injunction, direction to give reasons, prohibition, setting aside, and remission for reconsideration. Also mandamus, temporary interdicts, and other temporary relief, and an award of course. The Act elaborates further relief in proceedings relating to failure to act. The court may direct the taking of the action, declare the rights of the parties, direct parties to do or refrain from doing any act, or may make orders as to cost or other monetary compensation. Under Article 23(3) of the Constitution, in any proceeding brought by Article 22, a court may grant appropriate relief, including a declaration of rights, an injunction, conservatory order, a declaration of infirmity of any law, and an order for compensation, and an order for judicial review. In consonance with Article 23(2)(3) of the Constitution and Order 53 of the Civil Procedure Laws, the High Court, in the instant case, granted orders of statutory and mandamus. The Honorable Attorney General, in his written submissions at paragraph 47, submits that the orders granted by the High Court were an abuse of their discretion, that the learned judges had in law and in fact in granting the relief sought, thereby precipitating a constitutional crisis. He submitted that judiciary proceedings in their very nature are discretionary and must take into account public interest, that judicial review application falls within the ambit of public law, where determination of disputes usually proceeds viewed the protagonist before the court, and where issuance of orders sought may affect other parties not privy to the proceedings. The Attorney General submitted that in judicial review proceedings, the court has wide discretion whether to grant relief at all, and if so, what form of relief to grant. Dicta from the case of Judicial Service Commission ex parte Pareno was cited, where it was expressed that judicial review orders are discretionary and are not granted and are not guaranteed, and hence a court may refuse to grant them even when the requisite ground exists, since the court has to weigh one thing against another and see whether or not the remedy is the most efficacious in the circumstances obtaining. What is the national and comparative jurisprudence on the type of the orders issued in judicial review on matters relating to tender issues, public participation, and where time constraint exists? We have cited some authorities, 6 authorities.
Time constraint was not a relevant factor to be taken into account in determining the relief to be granted.
And
the cases here below,
which do not contain time constraints, and concluded that a common thread in all the foregoing cases that time constraint was not a relevant factor to be taken into account in determining the relief to be granted. The cases here below have time constraints as a critical factor in determining the appropriate relief. And we have the Supreme Court in the case of Communication Commission of Kenya, Fathers Royal Media Services, and 5 others, was faced with crafting an appropriate order in relation to procurement process where time constraints was a relevant consideration. The time constraint related to migration from analog to digital terrestrial television, which Kenya was required to comply with by 17th of June 2015, which was the switch-off date. The Supreme Court considered its judgment on 29th of September 2014 and directed the Communication Commission of Kenya, in exercise of its statutory authority and in consultation with all parties to the suit, to within 90 days consider setting timelines for the digital migration, as the Commission was directed to rewrite its operations and licensing procedure so as to be in tune with Article 10, 34, and 227 of the Constitution. We have referred to comparable cases from South Africa. At least, for example, the case of Black Search Trust for the Minister for Social Development, decision of the Constitutional Court of South Africa delivered on 17th of March 2017. We have referred to this decision extensively. And continued. This decision from the Constitutional Court of South Africa is not only informative and persuasive, but it addresses the challenges faced by the court in crafting appropriate remedy to a constitutional crisis when faced with the time constraints and violation of the constitutional values and principles, and the need to balance and uphold public interest. In crafting an appropriate relief, a court should take into account public interest or balancing all relevant factors and circumstances. A further ground of appeal that was urged before us is that the judgment by the High Court was internally contradictory. The appellant submitted that the order of statutory as granted by the High Court contradicts the order of mandamus that was also granted, that whereas the order of statutory was the contract awarded for all the 6 elections, the order for mandamus directed the novo tendering for printing of the ballot papers for only one election, that is the presidential election. That having quashed the tender for all the 6 elections, the High Court contradicted itself and held either for not ordering a retendering for the other 5 elections, or stating the reason why the other 5 elections remained valid despite a single tender contract having been awarded in respect of all the 6 elections. It was argued that if public participation did not take place in the tender for one election, then it also did not take place in the tender for the other 5 elections. The High Court thus held in failing to explain this apparent contradiction. The first respondent submitted that there was no internal contradiction in the judgment because all parties are clear in their minds that the procurement of the election materials for the 5 elections was not quashed. We have considered submissions by the parties, and we go by the terms of the decree or record. As per the decree, the order of statutory quashes the decision of IEBC awarding the tender for the printing of the election material, including ballot papers for the presidential elections. On the face of it, it would appear that the entire decision to award the tender was quashed. However, bearing in mind the various findings and final orders of this court, we find no good reason to delve into the issue of whether the tender that was quashed by the order of such right was for one or for all the 6 elections. Sorry, as we conclude the issue of the appropriate relief, guided by the Kenya Supreme Court approach and the South African comparative jurisprudence, we have the considered view that the trial court in this matter exercised its discretion wrongly without regard to the constitutional timelines within which presidential and general elections must be held vis-a-vis statutorily regulated timelines for various procurement activities. Judicial discretion must be exercised judiciously, and the trial court ought to have taken the matter before it as an exceptional circumstance, requiring exceptional appropriate judicial remedy for any violation of the constitutional or statutory values and principles. In granting the orders of lecturer and madamas, the learned judges held did not take into account the very real threatened breach of the rights of millions of Kenyan voters enshrined in Article 38(2) and 136(2)(a) of the Constitution, being the right to free, fair, regular elections based on universal suffrage. The learned judges exercise their discretionary power in error. We find that this is a case in which an appellate court can and should interfere with such exercise of discretion. Disposition and final orders. After extensive re-evaluation of the evidence on record, and upon considering oral and written submissions by all parties, and bearing in mind relevant laws and constitutional principles, we now come to the following conclusions, findings, and determinations. 1A. We make a firm determination that Article 10(2) of the Constitution is justiciable and enforceable, and violation of the article can found a cause of action either on its own or in conjunction with other constitutional articles or statutes as appropriate. B. We find and hold that subject to limited exceptions inter alia in Section 4(2), Section 6, and 91(2) of the Public Procurement and Asset Disposal Act 2015, and pursuant to Section 3 of the said Act, as read with Article 10(2)(b) and 227 of the Constitution, as a general principle, public participation is a mandatory requirement in all procurements by a public entity. We find that there are exceptions to public participation in the procurement process, and one such exception relates to direct procurement. C. In relation to direct procurement, subject to Article 2271 of the Constitution and the law on alternative procurement methods, the conditions stipulated in Section 103 and 104 of the Public Procurement and Asset Disposal Act 2015 are mandatory and exhaustive. They cannot be added to nor subtracted from. And D. There is no constitutional or statutory mandatory requirement that there must be public participation before a decision to adapt or use direct procurement is made, so long as procurement entity satisfies Section 103 and 104 of the Act, as read with Article 2271 of the Constitution. Direct procurement cannot be unconstitutional. However, the decision as to the winning bid and award of the contract is the sole responsibility of the procuring entity and the accounting entity. And we find that the High Court in this matter exercises discretion wrongly without regard to the constitutional timelines within which presidential and general elections is to be held vis-a-vis timelines for various procurement activities. In granting the orders of certiorari and mandamus, the judges erred and did not take into account the very real-threatened breach of the rights of millions of Kenyan voters enshrined in Article 38(2) and 136(2)(a) of the Constitution, being the right to free, fair, and regular elections based on universal suffrage. For various reasons stated in this judgment, the final orders of this court are as follows. A. The appeal has merit and is hereby allowed. B. The judgment of the High Court dated 7th of July 2017 be and is hereby set aside to the extent 1. That the court erred in finding that public participation is a mandatory requirement in direct procurement. 2. That the court erred in granting the orders of certiorari and mandamus without due weight and consideration to public interest, and the statutory regulated timelines for the tendering process embodied in regulations 36, 40, 46, 54, 5 of the 205 procurement regulations 205 and section 80 subsection 6 of the Public Procurement and Asset Disposal Act 2015. And C, to the extent stated in this judgment, the close appeal lodged before this court by of notice of close of appeal dated 12th of July 2017 be and is hereby dismissed. D, the upshot is that the orders of certiorari and mandamus issued by the High Court be and are hereby set aside. And A, for avoidance of doubt, the constitutional date for this year's general elections is 8th of August 2017. Each party is to bear his or her own cause in this appeal, and the High Court will now sign the judgment, all of us.
This did.
Will be available within about 1 hour from now, and we thank you for the help the court to reach this decision. We cannot ignore
the copy of the certified copy of this judgment will be available within about 1 hour from now, and we thank everybody who have helped the court to reach this decision. We cannot ignore the input from all the councils participated in these proceedings, and the support from everybody, including the patients in giving us time to write this judgment. Thank you very much. Yeah.
On both sides, to express our appreciation with the bench, with the manner in which you listened to all of us, I think led into the night. And of course, the manner in which you've been able to come with a fairly exhaustive judgment within very limited time. And I think our appreciation as a bar should be recorded. We thank you.
Yeah, thank you very much. Oh yeah, thank you. He appeared in person on behalf of the independent candidates and voters. Yeah.
Personally, my appreciation as well for the short time that you have also mattered. You know, when we ended our submission on Friday, that was the time you started working. I know you done midnight oil with all the volume of work that was there. On behalf of independent candidates, we are very grateful, and you join in now the heroes and the heroes of this country who are unsung and who are never known, that were working every day to make this country a better place. Thank you very much also for the senior council for having allowed me to be enjoined in as interested party. If I had been with a junior, maybe they would have called me a busybody. And now, thank you very much. And also for the members of the press, thank you for giving the nation at home. May God bless you. God bless Kenya. Thank you.
Thank you, everybody, including the press, for the role they are playing to inform the public. Yes.